Okay, hello everybody. We're back again with we are now part 5 of the original basically series I was doing about the state's original brief in their appeal of Magistrate Duffin's decision. And what I've been doing for the last couple of videos is looking into the cases cited by Brad Schimmel in the state's brief, their first written brief that they filed, and looking into that case law that he's citing, and looking into what was, a little deeper into those cases that he's citing. And personally, what I keep finding is they're not really like Brendan's case. They're really in almost very little like Brendan's case. They don't resemble it really. And I'll get into that. You'll see here in this video. And also in the last one too. The last one, the last case was Gilbert versus Merchant, and it was a gang member, and then this one again, another gang member. So, gang members tend to be pretty savvy individuals. They understand what's going on when they're in the police station, because they've been getting into trouble. They understand consequences, and they're aware of the fact that the police are going to be looking to pin the crimes on them and stuff. So, that's part of that culture. Not saying it's right or wrong. I'm just saying it's part of that culture. So, anyways, we're going to move on here to look into this case that we're talking about today, which is Ruvalcaba versus Chandler. Mr. Ruvalcaba, it's in some ways pretty interesting, and I'll get into talking about it. But for one thing that's interesting about it is that he went to court when he went to trial on this the first time. The jury voted that he was acquitted of murder, first-degree murder, but the jury got hung on the remaining 2 charges, and because they got hung on those, the whole thing went out. And then in the second trial, he ended up getting found guilty on all 3 charges. And I think that is pretty messed up and pretty interesting, kind of on its own. But I thought that was, I don't know. I mean, can you imagine that if you went through a whole trial and a jury actually acquitted you of the main charge that you were facing? But then, because they couldn't make a decision on the other lesser charges, you're suddenly back into the frying pan again. Anyway, I don't know. That just seems a little bit odd. Almost seems like double jeopardy. I don't know, but obviously in law, it's not that way. He obviously wasn't he wasn't acquitted because they couldn't decide on the other 2 issues, I guess. So there you go. It's thrown out. But yeah, interesting nonetheless. So, but we're going to get into it here, and we're going to see that Mr. Ruvalcaba is pretty much aware of what's going on. The problem that they have with his claim when he files for habeas relief and stuff like that is that a lot of the claims that he's making, he never said one word about them during the original proceedings and the original trial and stuff like that. And that's their main problem with him, and when they're trying to determine the merit of his claims here. But the thing that I think is really important, I'll get to in the second document I show you. But right now I'm going to go ahead and put up the document that kind of shows you, just basically gives you the basic story of this case and what happened with Mr. Ruvalcaba, and kind of just the basic facts of the case here. So I'm going to show you that right now. When he was 16 years old, Mr. Ruvalcaba, together with 2 other members of the Latin Kings gang, Juan Meneses and Juan Alvarez, encountered rival La Raza gang members, Carlos Flores, Hiro Martinez, and Luis Sanchez. This confrontation took place in a Chicago alley on November 7th of 1994. Early in the day, someone had broken a window on Meneses' car, an act of vandalism that he attributed to La Raza. Meneses and Mr. Ruvalcaba were both armed. The two groups exchanged gang signs. According to the La Raza survivors, Menezes and Mr. Ruvalcaba drew their firearms. Flores, Martinez, and Sanchez attempted to run away. According to Mr. Ruvalcaba, Menezes and Flores began shooting at each other, and he joined in. Regardless of who initiated the altercation, Menezes and Mr. Ruvalcaba both fired. The latter testified that he fired only one round towards a fence in the direction of the fleeing rivals. Martinez was killed in this exchange of gunfire. Police investigation indicated Mr. Ruvalcaba's involvement. The two officers went to his residence. Mr. Ruvalcaba's brother informed them that he was not there. The officers left, arrested Alvarez and Menezes, and then returned. No one answered the door at Mr. Ruvalcaba's residence, so the officers left a business card. They learned that Mr. Ruvalcaba had a girlfriend, Diana Caguana, and they arrested Mr. Ruvalcaba at her residence at approximately 11:30 p.m. The police then returned to Mr. Ruvalcaba's residence to notify his parents of his arrest, but when officers arrived there, no one was home, and the business card remained in the door. So you can see that Mr. Ruvalcaba was leading a pretty independent lifestyle, didn't have a whole lot of parental guidance or anything going on, was probably learning a lot on the street with his fellow gang members and buddies in his gang. So we know he's a whole different situation compared to Brendan in terms of experience and back. All right, there we go. So we see there basically the basic story. Mr. Ruvalcaba and a couple of his gang member friends, or his certainly two of his gang member friends got together because Mr. Menzies' car window had gotten broken. He immediately thought it was the La Raza gang, and they went and found these couple of members, Flores, Martinez, and the other guy from La Raza, and they exchanged gang signs, and then next thing you know, gunshots ensue, and Mr. Martinez ends up murdered or dying from gunshot wounds. So there's the two other members though of the La Raza got away, eyewitnesses. It's kind of hard for your confession to matter when there's eyewitnesses. Because, fine, Mr. Ruvalcaba, we take away we take away the confession. You never confessed. Now what do you do about the two witnesses that are there and fingered you and that can clearly say that you fired shots? So but anyways, that's here nor there. He basically obviously was involved. You can't deny that. But let me get into the other thing about when they go to pick him up here. For a 16-year-old, this kid didn't act much like a 16-year-old. Because I know that when I was 16 years old, and I think most people experienced this in life, when you got home from school and stuff, you were expected to be home from school because your parents were there. And your parents didn't let you do stupid stuff. And you certainly weren't allowed at 16, most of us, to go and spend the night at your girlfriend's house. Okay? This kid's got a lot of freedom and everything. This kid, he knows what's going on. He's not like some, dumb kid. I mean, some of his choices in life are unfortunate, but hey, Chicago is a rough area, so I'm not going to be too judgmental on that, and he's probably from the poor part of town, and got into the gang lifestyle because he felt it was a better option than whatever else he felt was out there as an option, but and there may be something to it. Like I said, Chicago's got it pretty rough with the crime and stuff, so anyways, but my point here is that with this case, I don't really know what good it does taking away his confession in the first place. So, but anyways, he made his petition, and it was heard by this court, and it was ultimately denied. But we're going to go into right now where this court talks about what the standards are in determining the voluntariness of a confession, and the factors that are involved. And then I want you to remember that Mr. Ruvalcaba was a pretty savvy 16-year-old gangster, you know. A far cry from the 16-year-old Brendan, who had pretty much been keeping his nose clean his whole life, wasn't really out to hurt anybody, you know, wasn't getting into trouble, and certainly wasn't allowed to just go leave his house and go spend the night at a girlfriend's house, I don't think, you know what I mean? So, at will. So, not at 16, you know what I mean? So, it's you know, two different types of kids here. And the reason why I bring that up is because it's part of the factors that they use to determine the voluntariness of a juvenile confession. And those factors are age. Okay, they're both 16, fine, granted, they're both 16. Experience, we both can, I'll tell you right now, Mr. Ruvalcaba's experience in being a you know, gangster on the local streets in Chicago where he grew up is much different than Brendan's experience of growing up on the Avery salvage yard and keeping his nose clean his whole life. Education, I don't know exactly what Mr. Ruvalcaba's education was, but I don't know. I imagine he was getting by, was, you know, probably wasn't big on doing his homework. But I don't know. I don't know what his actual school life was like. But I gotta imagine education is probably fairly similar between the two. Background, two different backgrounds really. And then the final one is intelligence, and it's a huge one. The intelligence factor is huge. And if you guys remember, Night Rider points that out in her brief, that Brendan's case more resembles the case of the involuntary, or the confession that was deemed involuntary by the court, which was AM versus Butler. And that was the 11-year-old. Okay, that was the 11-year-old that was coerced into a confession by police. That was a case that this court deemed the confession involuntary. And she makes that connection in her brief, where she says Brendan's case more closely resembles the AM versus Butler that the state cited in their brief of involuntary confessions. So, and I think she's right, but Brendan is not on par with Mr. Ruvalcaba when it comes to, you know, basically intelligence and understanding his rights when they're being read to him, and understanding what it means when the police are there talking to him and being all grandfatherly and all that, and he just he didn't understand it and comprehend it the way that Mr. Ruvalcaba did. I'm absolutely certain of that. So I'm going to go ahead and move into this document here where it talks about those factors. It talks about Mr. Ruvalcaba and how they use these factors in his determining determining that they were going to uphold his confession as voluntary. But I'll go ahead and show you that document right now just so you can see those, because I think it's important, because, you know, Schimmel keeps citing them in his paperwork, but I honestly am making my criticism of, okay, yes, those factors are different with Brendan than they are in the cases that you're citing, Mr. Schimmel. So, you know, but we'll see here. Let me just go ahead and show you. We turn now to the determination on whether the decision of the Appellate Court of Illinois can be characterized as a decision that was contrary to or involved in unreasonable application of clearly established federal law, as determined by the Supreme Court of the United States. The applicable standard is established firmly in jurisprudence of the Supreme Court in evaluating whether a defendant offered a voluntary statement. A court must examine the totality of the circumstances surrounding the interrogation. Shelnick versus Busbani. This totality of the circumstances approach is adequate to determine whether there has been a waiver, even where interrogation of a juvenile is involved. In juvenile cases, the inquiry includes evaluation of the juvenile's age, experience, education, background, and intelligence. It considers whether he has the capacity to understand the warnings given to him, the nature of his Fifth Amendment rights, and the consequences of waiving those rights. The appellate court of Illinois recognized that it was required to evaluate the totality of the circumstances surrounding Mr. Ruvalcaba's confession and undertook that task. Therefore, the court was not acting contrary to clearly established law. All right, so there we see the main factors involved in determining the voluntariness of a juvenile confession, which are obviously age, experience, education, background, and intelligence. And the main point I'm making here is that these cases so far that Brad Schimmel has cited in his brief are really not like to Brendan or his case. They're not similar because the defendants are very much different than Brendan. They're clearly not as susceptible to suggestibility as Brendan. I'll say that. And so far, 2 of them were gang members. So gang members tend to be pretty savvy, and they understand what it means when they're at the police station. That's all I got to say about that. They know when they're at the police station that generally it's not because the police are wishing them well. No. So I think though they were in terms of experience and background, they were in a much stronger, better position to understand their rights than Brendan was. So that's my bone to pick with these examples that Brad Schimmel's making, is that they're not like Brendan's case. So I don't see how they strengthen his argument really in any way. So I agree with Laura Nyrider that Brendan's case more resembles his example of a case that the Seventh Circuit Court ruled that the confession was involuntary, and that was AM versus Butler. And that was where an 11-year-old was basically had an officer like pounding on his knees kind of whenever he felt that the kid wasn't telling the truth during the interrogation. They told him that they showed him fingerprint evidence that his fingerprints were on the murder weapon, which was false evidence. And they also told him that if he confessed, that them and God would forgive him, and he could go home for his brother's birthday party, which constitutes as a promise, which is a big no-no, huge no-no. So, this kid ended up getting off, but the thing is the kid was 11 years old. Okay, very unsophisticated. Didn't understand that. At that age, don't understand. You look at the cops and you still have respect for them. You don't think that they could ever do anything bad or anything like that. And so that kid must have been in a bewildering situation there, with this cop getting physical with him and like pounding on his knees a bit and calling him a liar or whatever. So anyway, that confession was ruled to be involuntary by the Seventh Circuit Court, and Nyrider makes the case that Brendan's case more closely resembles that case. Okay, so that's about it, folks, for this video. I think I've made my point about the examples that Mr. Schimmel has made and how they're not really, they don't fit. So, anyways, I'm probably going to go on. I'm going to see if I can find, so far I've been unsuccessful, but I'm going to see if I can find some more information about the confessions that the Seventh Circuit Court deemed involuntary. So far I haven't been able to find anything about those 2 cases that were in Brad Schimmel's brief. But I'm going to see if I can find something about those, because I want to look into them and look a little closer at some of the facts on those and do a video on them for you. So anyways, that's about it here for me, folks, on this video. If you haven't already, please hit subscribe, and we'll see you later.